Welcome back, everyone. We're going to turn now to really stunning news here for Kennedy cousin Michael Skakel. His conviction overturned for the killing of a neighbor back in '75. Now, Skakel, he is now demanding to be released from prison while he awaits new trials. Michael Skakel's murder conviction may now be overturned, but if prosecutors have their way, he'll stay in prison while he waits for a new trial. Skakel, nephew to Bobby Kennedy's widow Ethel, was convicted of killing his neighbor and friend, 15-year-old Martha Moxley, in 1975 on Halloween night. The murder, it remained a mystery until Skakel was convicted back in 2002, 25 years after the murder. His sentence, 20 years to life. Moxley's brother John says the upcoming trial is opening old wounds.
So this retrial, is it for you like jumping into a time machine that just keeps taking you back to this really painful time?
Oh, it's a death of a thousand cuts. Every time you do something like this, it definitely takes, hours, days off your life.
Skakel has always maintained his innocence.
What I do every day is pray to God and to Martha that whoever did this crime is brought to justice.
But why the sudden retrial now? Last week, a judge ruled that Skakel's former lawyer, Mickey Sherman, did not provide a constitutionally adequate defense and that the failures were significant. Robert Kennedy Jr., who says his cousin didn't do it, agrees.
He was preoccupied with glitter and celebrity. He said at one point to the Bar Association when he spoke to them, he said he intended to have a lot of fun on this case. And, there was a man's life at stake.
Did that lawyer get caught up in the glitter and celebrity of it all?
Well, I think Mickey clearly enjoyed it, but I think that's his personality type. Did it make him a bad lawyer? No, I don't think so.
When you hear the Kennedys say that, what do you think?
I think that the Kennedys will say whatever they want to say.
And for more, I want to bring back James Soros, as we said, a criminal defense attorney who has specialized in criminal defense litigation for more than 20 years and has had more than a few high-profile cases himself. And I want to break this into a few pieces. I spent a lot of time covering this trial originally when it came up, and we had Mickey Sherman on more than a few times. He certainly didn't fight to, avoid the camera, that's for sure. But of all the things that would bring this to a retrial, 20 years later, I didn't think was going to be the source of it. Let's go back for a second and explain to Dominic and I in the audience some of the curious elements of this case, and maybe as a defense attorney, what didn't surprise you that might have surprised me at least, or even surprised you. And that was, we had a case in '75, obviously. The conviction didn't happen in '75 or even close to it. Fast forward many years later. What got Michael Skakel convicted, to the best of my recollection, was testimony from people who, this was all second and third hand, heard him talk about a rehab place, what he may or may not have done that night. A guy that was sharing a cell with him for, I think, all of 1 or 2 nights, who basically turned out to be a jailhouse informant, snitch, whatever you want to call him, who talked about this. And at the end of the day, Skakel was a minor, and I'm sure he's a bad guy. I'm not trying to, ascribe any terrific motives to this person here. That said, he was a minor when he did it, and the laws in the books for minors were a lot different in terms of sentencing than 20 years later when he gets in front of the court and he gets treated as an adult. So let's take this in pieces. Help out people as to what is and isn't admissible, or should or shouldn't be admissible in court when it comes to testimony of people who allegedly heard you confessing or talking about a crime, and how much credibility you give these people given the settings they heard him in.
It's so dangerous. I just cannot tell you, living it for 25 years and seeing it. When you have people who give testimony in return for something, you've got jailhouse snitches who want to get out of jail, and all of a sudden the person next to them is confessing. You've got, in this case, and something that troubled the court so much, this guy Coleman, who is a confessed heroin addict, who says that this gentleman confessed him 25 years ago, which, by the way, they had that evidence 25 years ago, and it obviously wasn't enough back then in order to prosecute the man, only to then find out that people that supposedly were around him when this confession was made now come forward and say that didn't happen, or something to the effect of Skakel at the time said, I didn't confess to anything. It is so dangerous. You know, people out there, you know, and you say you're sure he's a bad guy. Why? We don't know if he's a bad guy. People think he's a bad guy because he was convicted of murder. He may have not committed the murder. He may have been a young teen who had a drug problem that needed some help. We don't know what he was.
You know, I'm curious because you've covered a lot of high-profile trials. You've worked a lot of them. There was always a debate at the time. He got preferential treatment at the time because he was a Kennedy, if not by name, by relation. Do you think high-profile defendants get breaks that regular defendants don't, or are they held up to a higher scrutiny because the jury pool, by just definition, isn't going to give them the benefit of the doubt because they think they've had every advantage known to mankind?
Excellent question. Sometimes they get preferential treatment, but oftentimes, more than not, they are held up to a very high standard, especially the Kennedy name. No one wants to be accused of giving away the store to them and letting them get away with literally murder. And so every dot is dotted, every T is crossed in most cases. So it works both ways.
You think if you put it to a poll, though, about the Kennedys, they'd say a timeout.
Right,
you go
they'd
to
say you walk away.
You go to the Smith case down in West Palm Beach. You go to this case. Look how long it took for this guy to see his. You've been on the other side of this, on both sides actually, but what do you think the answer is? Does it help to have celebrity when you go in front of a jury or no?
You know, I don't know that it helps when you go in front of a jury necessarily. We all know that in our country, one of the problems is the inequity and inequality of people who have money to hire a really good defense attorney and really get good investigators that
you're
can
not
do.
pro bono?
That can do. Sometimes I am. Sometimes I mean, it's a fact. We all know that. But when it comes to the celebrity, clearly they had the money to hire counsel and investigators that this court found were not put to good use. But I agree with Dominic. In this case, they prosecuted him 25 years later. It didn't affect the prosecution in this case. They went after him notwithstanding the lack of any real proof. The courts that reviewed the case shot him down. You found a judge here who was really concerned with the effectiveness of counsel and what was done and what wasn't done.
Just one more question
Sometimes
on the
it helps,
celebrity thing,
sometimes it
because
doesn't.
as many people may know, you've defended the Gotti family at trial here more than a few times. Do you think his last name, well, certainly it made for a target here with feds, but beyond that, did it help or hurt when you're looking at a jury pool and you're trying to figure out, do people by nature, you know, like the rogue and, you know, are going to look for a reason to help? Or are they saying, you know, by definition, I'm coming in with preconceptions of this guy. He's going to have to be innocent. He's going to have to prove he's innocent. I'm going to assume he's guilty. Which one did you find more often than not?
Well, what you need to do when you're looking at the jury pool is you need to look and try to find the people with the preconceived notions, and you need to not have them on your jury. And then it is my belief that most people, even those with, we all have preconceived notions. We all think what we think based on the way we've grown up and our experiences. I truly believe that when they get in that jury room, they are mostly unaffected, and they look at the evidence, and if you've got good lawyering, then they know just what is riding on things. You look at these high-profile trials you've had over the last few years. Was there any pressure that you could think of except those jurors in the Casey Anthony trial, where the entire world, forget about the country, thought she was guilty, and they came out with the verdict?
Do you have an instinct during the trial when you're looking at the pool that there's one over there, that guy's going to be trouble? Do you ever get a sense?
Oh, you know something, you look at the jury and the one that you think is trouble is the one that comes running after you after the trial saying, you were great, you had me from go. Sometimes you're right, sometimes you're wrong. Look, some people are very, you know, demonstrable, you know, in their lives, and they'll be sitting on the jury and something will happen and they'll react, and you know it's good or you know it's bad. Otherwise, you can be looking at somebody who's stone-faced and you think, oh boy, I'm losing this one. And you're wrong.
But you know, Richard, and I don't know many of the details of this case, like the lawyer I haven't covered this trial. But you can't just want bad things to happen to this young man, or grown man, whatever, you know, because he's related to a Kennedy, because that name is associated with it.
I do remember, think, though, and I remember covering this, though, Dom, I do remember this prevailing feeling, at least outside the courtroom,
Preferential
that
treatment.
Kennedy's once again getting a break here. And I always thought that in this particular case, one of the things that always stood out to me was, okay, the guy was a teenager when this happened. The victim, by the way, was only 15 when she died. The law in the book said that if they prosecuted him then, at the age that he committed the crime, he would have been treated as, and would have been sentenced as, if found guilty, as a juvenile.
As he should have been.
But then they choose to bring the case 20 years later